It's online.
Outstanding start. Okay.
It sounds muffled.
Same.
Not clear.
Not clear.
We're better off without it, Dave.
I'm kind of thinking that. Is that better?
It's getting there.
That's better. Robert, can you dim the lights? Jim? Can you hear me now? No?
Yeah.
All right.
We can do it still, it's being broadcast, so they don't, they can't hear you.
Can you hear me now?
Yeah.
They still talk, but they're. Otherwise, the broadcast, they can't hear you. We got over the number we have in.
Very well. Welcome. It's nice to see so many of you out here today. It has not escaped your notice that we are not meeting in the Cherokee room because of the burst pipe and the damage to the AV equipment and the damage to the room. What that did was set off a flurry of activity by a lot of our CFPOA staff members, some of whom are here today. Most notably to my right, Robert, Casey, and Zach of our IT and AV team, who have spent countless hours trying to engineer this thing, which we all, I'm sure, really appreciate. Glad we have the redundant space where we can make the presentation. I was over here yesterday to check on things and ran into Charles Kitchton and his staff coming around with stacks and stacks of chairs that they were moving from the Cherokee room over here into the Hemlock room. Just a beehive of activity. And shepherding all of this, of course, is our great general manager, Jim Whitmore. So thanks to all of you that have made this presentation possible today in terms of preparation of the venue and allowing us to share some important information with the community. Today's presentation is envisioned to last 1 hour, I hope, no more, with time after the presentation for question and answers. Please hold all of your questions until the end of the presentation, and we will try to answer them to the very best of our ability. Also joining me here today are members of the CFPOA Board of Directors. To my left, President Jim Bailey, Vice President Richard Zollinger. I saw Carl Terrell, he's in the far back. Carl is joining us despite suffering symptoms of the Connestee curse, that being a steep, icy driveway resulting in a fall. So Carl, thank you for being here. Director Larry Rourke and his wife Lorraine are on a long planned vacation in New Smyrna Beach, Florida. And who's the other one? Me. Okay. I tried to schedule voluntary spleen removal surgery today, but unable to do so. Here I am to share some time with you today. I direct your attention to the screens. I wish we had a big screen. I'm sorry we don't. We're going to do our best. I'm going to do my best to walk you through them. You will notice that this is a very, for lack of a better phrase, and sadly, wordy presentation. There's a lot of slides with a lot of words on them. And that's because of the scope and breadth of the information that we need to share with you today. So I apologize in advance but get ready to see a lot of words on a lot of different slides. Note the title slide. This is an update. This is not a report. This is to share information with membership, provide them facts and background that they may not have at this point. So let's go ahead and get started on the presentation.
I'm sorry, your full name?
Thank you very much. My name is Dave Hunter. I
Thank you.
apologize.
Thank you.
I am a board member.
Thank
This is an outline of the presentation. The first slide will define what this presentation is and what it is not. We're going to review the short-term rental task force, both the charge received from the board on September 4th of last year, as well as the roster of task force members. We're going to do a very brief overview on the short-term rental industry today. We're going to look back at the history of short-term rentals at Connestee Falls from 1971 right through 2024. We're going to briefly describe the current state of CFPOA and short-term rentals today. We want to share some preliminary information with you about the renters, the plaintiffs, and other related data. We want to share with you the key findings and recommendations of the task force, share a summary, briefly outline next steps, and then entertain your questions and answers. What this presentation is. This presentation fulfills the requirements of the charge given by the board to the short-term rental task force on September 4th, 2024. We're going to go through that charge in just a moment. This presentation is an attempt to provide membership with information and facts that they will need to help heal and guide our community going forward. This presentation is a demonstration of this board's commitment to transparency and engagement with membership. As important, perhaps more important, what this presentation is not. This presentation is not a reversal of any policies currently in place concerning the operation of short-term rentals within Connestee Falls. It is not an announcement of any unilateral board action concerning the operation of short-term rentals within Connestee Falls. It is not a relitigation of the consent order. It is not a relitigation of the declaration of the fifth restatement. So let's be clear up front as to what this presentation is and what it is not. Let's talk about the charge. This charge was approved by the board, the full board, and there's four main components. The first is recruit a short-term rental task force of CFPOA members with a diversity of opinions and backgrounds on the topic of short-term rentals in Connestee Falls, a record of service, institutional knowledge, and leadership at Connestee Falls. It is to conduct a review and prepare a member presentation regarding the history of CFPOA management of short-term rental activity through the consent order of August 2024. It is to share lessons learned, key findings, and best practices to be adopted in management of similar challenges in the future, and is to describe where we are today with short-term rentals and recommend next steps. Where do we go from here, if anywhere? It is to develop recommendations to the CFPOA board regarding optimal STR management practices and other STR-related tasks as assigned by the CFPOA board. That is the charge received by the task force. You will see that the presentation, as we go through it, aligns with those four key bullet points. The roster. I'm going to refer to my notes here. The roster 7 members of the task force. I'm Dave Hunter. I'm a CFPOA director and short-term rental task force lead. I'm a retired banking executive. Don't hold that against me. I couldn't find honest work. I'm a former CFPOA board president, board treasurer, finance committee chair. I was the lead of the 2022-23 build-out task force. And back in 2018, as a new board member, I was charged by board president Marty Hodgkins and that board to spearhead the recruitment of a new general manager that resulted in our hiring of Jim Whitmore, April 2018, Jim. So it's been 7 years. So that's me. Also, Tom, if you just stand up briefly when I mention your name, you can sit back down. Tom Colleton is a retired corporate lawyer. He is the CEO of was the CEO of his New York Condominium Association. Tom is the recently retired Judicial Committee chair here at Connestee Falls. He's still on the Judicial Committee. And he was also a member of the Connestee Falls Build Out Task Force. Thank you. Michael Crane. May I also mention, Tom and I are both full-time residents of Connestee Falls. Michael Crane is a part-time resident of Connestee Falls who does not rent out his house. He is the director of accounting and finance for Blue Cross Blue Shield, specializing in contract review and compliance. He has prior service as an HOA president in South Carolina. Marty Hodgkins, who is here with us today. Marty is a retired urban planner, former CFPOA board president, board treasurer, chair, I believe, of the A&E committee, member of the finance committee, member of the 2022-23 build out task force. Rob Kurzreiter is not with us today. Rob is a part-time resident of Connestee Falls. He and his family have a second home up here. When they're not here, they rent their home. Rob is a realtor with Keller Williams in Orlando, Florida. He's principal of the Kurzreiter Property Group. Most interestingly, Rob is a former member of the Blue Man Group. Rob was a Blue Man and over a number of years transitioned into production, direction, design, and so on and so forth. Rob is not with us today because he's in New York City because Blue Man Group is closing their show up there after a number of years. And he's been asked to participate. He's hoping it's behind the scenes, but he says he's willing to once again put on the blue paint if called upon. Rob also was a key mediating force during the litigation. Constantly trying to come up with, along with CFPOA admin and counsel, ways to avoid litigation. He was a mediator. Steve Meadows is not with us today. Steve is the retired chief operations officer of Allied Irish Banks. He is the former chair of Kimbrell Food Furniture Company and is current director of that company. He is a former finance committee member and a key advisor at earlier attempts to upgrade IT here at Connestee Falls. Last, Mike Riley. Mike Riley is a part-time Connestee resident who rents his property. He also manages 5 properties here in Connestee Falls. He has a short-term rental management company and he manages other properties around the region and also has a short-term rental consultancy. So he is what I would deem a subject matter expert, particularly in the management of these properties. Let's talk about the industry. Tremendous growth. This data is from Granicus Host Compliance. You're going to hear about them more later. But there's been a 15-time increase in STR listings since 2011. Short-term rentals currently outperform hotels in 27 global markets in terms of average daily rates and average occupancy. There are When this data first came out, there were 60 currently active online rental platforms. We believe that number now is closer to 100. You've all heard of Airbnb and VRBO, but there's a bunch of others of them out there. And given this explosive growth, many communities, quote, struggle to define and enforce regulations that ensure revenue collection and support preservation of community safety and character. That should sound very familiar to all of us. That's a struggle that we're all concerned about. Again, the source of this is from Granicus Host Compliance. This part of the presentation begins the timeline and history of management of short-term rentals at Connestee Falls. Connestee Falls was incorporated May 15th, 1971, as the Connestee Falls Development Corporation. The original declaration of restrictive covenants is dated May 25th of that same year. That original declaration makes no restriction on rentals at Connestee Falls. In fact, it's the fourth restatement of the declaration that was approved by members in 2009 that first introduces the no transient tenants language found in Article 18 of our Declaration of Restrictive Covenants. Even though that language was incorporated into the declaration in 2009, CFPOA imposed no limits on the minimum lease terms of short-term rentals. They continued, despite the no transient tenants language, to approve leases of as short as one night. There were several board-appointed task forces that studied this issue in 2012 and 2016. Let me stop here for a minute and just mention parenthetically to you. Some of the information, much of the information that we have on this timeline comes from CFPOA records. Some of it was not readily available to the board in CFPOA records. This information came to the attention of the task force as we reviewed the matter over the past 5 or 6 months, and we felt it was important to share this information as to past efforts, since we're talking about the history of the management of short-term rentals at Connestee Falls. So there were two board, and a lot of this information right here was not available to the board. Both of those task forces in 2012 and 2016 reported no significant security or rule violations issues due to renters. A lot fewer of them back then. They recommended emphasizing rules enforcement versus STR restrictions. Both task forces warned against minimum rental period restrictions as being more likely to lead to litigation. And both task forces recommended clarifying the no transient tenants language in the Declaration of Restrictive Covenants. Now, again, these efforts of these task forces, there are notes out there, there are meeting minutes out there. Some of those were not found in the records of Connestee Falls and came from the individual files of former board members. That's an issue. Who's quacking? Is that a commentary on the presentation? Is that a ringtone? The no transient tenants language from the fourth restatement was unchanged in the fifth restatement of 2016. And despite the no transient tenants language remaining the same in the fifth restatement, again, CFPOA imposed no limits on the minimum lease terms of short-term rentals. We continued approving leases with terms as short as one night. By late 2016, the board sought legal counsel as a result of the task force work to clarify the no transient tenant language found in Article 18 of the fifth restatement of the Declaration. That opinion came from then counsel Robert Dungan, who stated that he did not believe that under the newly adopted declaration, the 5th, the association could restrict rentals based on time, except for prohibition of nightly stays as with a hotel or motel. Further stating that the term of the lease is up to the tenant and the member. By the way, Robert Dungan is the copyright holder of the lease form that we incorporate in our Declaration of Restrictive Covenants. And so his comment was, the term of the lease is up to the tenant and the member. So by June of 2017, the board proposed a member vote on a 6th restatement of the declaration to replace the no transient tenants language with language that said no less than 2 consecutive nights, clarifying the language as proposed by Counsel Dungan. In July of 2017, members voted to approve the 6th restatement by a vote of 76% to 24%, as reported in the Connestee Falls Election Committee vote count results document on July 28, 2017. That document was not in the possession of CFPOA. That document was found in the personal files of a former board member. That's a big issue. Okay.
I wasn't here that.
I was, in fact, I went on the board for the first time probably 5 days later. So, for unknown reasons, the 6th restatement is not on file with Transylvania County Register of Deeds, and we've been able to find no signed copy. Now, let me tell you what that means. Michael Crane is here with us today. I introduced him, Blue Cross Blue Shield. Michael was a real thought leader in a lot of this. And back on November 5th, I get an email from Michael saying, guess what I found? The 3rd restatement. Not only is the 6th restatement not on file, the 3rd restatement is not on file. So 2 out of our 6 declarations of restrictive covenants are not on file with Transylvania County. Most interestingly, the 3rd restatement is stamped with book and page numbers and is signed off by an official of the Register of Deeds saying that it has been filed. So they accepted it, they stamped it, they said they filed it, it ain't on record. That's a problem. So from 2017 to 2023, Connestee Falls approved leases with terms as short as 2 consecutive nights, consistent with the member vote, despite the fact that the restatement could not be found on file with Transylvania County. Now, when we found out that the 3rd had been found, I called Robert Dungan, the attorney at the time of the 6th restatement, just on the off chance that he had a signed copy of the 6th restatement. He said he would look in his files and get back to me. We spoke the following day. He has no signed copy of the 6th restatement. Again, this is all important milestones kind of in the history of management of short-term rentals, consistent with the charge given to the task force by the board to prepare this timeline of this history. So from 2017 to 2023, the association received feedback voicing concern about allowing STRs within Connestee Falls. I'm going to stand here right now and tell you that if I had a magic wand or pixie dust and could make the decision on my own, we would have no short-term rentals at Connestee Falls. I'm not in that position to do that. So I was probably in that camp that said, you know, I just assume not have them. And there were assertions made also that allowing those short-term rentals are a violation of the 5th Declaration of Restrictive Covenants. Now, while this flow of information to the board expressing opposition to the STR concept continued, relatively few complaints are received by CFPOA regarding specific renter violations. Now, this is a key point. There are likely some complaints that either were not reported at all or were resolved between the parties without involving CFPOA. So we have data about those complaints that were registered with the association. We do not have data about the volume of complaints that were resolved in other ways or were not registered at all. CFPOA the security has repeatedly said that when they have received complaints, they have been quickly addressed and resolved with no pattern of repeat violations or nuisance properties. That when those complaints are brought to the attention of security and security goes out and visits the violating property, the noise stops, the lights get turned off. The only exception, the only time they had to go out there twice, according to Chief Mike West in recent past, was when the house was being rented by, quote, 4 college-age males. I vaguely remember being one of those. And I'm not surprised that a repeat visit was necessary. In August of 2023, a new board was seated, and they identified in their board business letter short-term rentals as a key priority. They said the board is going to carefully study the concerns raised by CFPOA members relating to short-term rentals within the community. This topic is not new for Connestee Falls. In fact, there is documentation dating back to 2012 showing it was discussed with the CFPOA retained law firm at that time. Short-term rentals are not only a concern in Connestee Falls, they are on the agenda of many cities and residential communities, including Brevard. The first task that we, the board and administration, will undertake is to meet with the law firm that CFPOA has on retainer to obtain a legal opinion on North Carolina and Transylvania County law related to short-term rental properties. Once that legal input is obtained, the next steps for this initiative will be determined. That's exactly what they did. They went out, sought counsel, got the opinion, and then announced the next steps that were determined by the board. They said what they were going to do, and they were good to what they said they were going to do. So in September 2023, the board conducted a review of the governing documents. The board engaged legal counsel to evaluate whether the fifth restatement of Declaration of Restrictive Covenants for Connestee Falls contains a short-term rental restriction. And if so, what short-term rental restriction is supported by the terms of the Declaration's restrictive covenants and other STR-related concerns. For example, the potential of grandfathering existing homeowners into current practices. For example, give us advice on, gosh, our documents have said this for a long time, and we have not been, we've been approving leases up to, as short as 2 nights. Does that mean anything? So those are the types of things that the board sought counsel from our attorney. On September 19th, there was a chat with the board. That chat was dominated by discussion of rental concerns. And on October 4th, the board received a legal opinion from CFPOA counsel, which says that the terms of the declaration support a requirement of monthly or longer rentals in the community. At the time the opinion is given, the CFPOA counsel is unaware of the 6th restatement. Upon being informed of the 6th restatement, the attorney expressed concern with filing the 6th due to the passage of 6.5 years' time and the associated member turnover. So in 6.5 years' time, probably close to half of the homes within Connestee Falls had been sold. On October 15th, CFPOA received notification of the formation of residents of Connestee United, or ROKU, in a memo signed by approximately 40 member households, and stating that Roku's intention is to see that the prohibitions against transient rentals are enforced. On November 8th, 2023, the board announced to the members the decision regarding SDR restrictions based on the legal opinion. And on November 15th, in a follow-up board email, the board stated, after receiving the legal opinion, it became the board's responsibility to enforce what is in our governing documents. And it is the board's responsibility. Between November 10th and November 22nd, the board received 161 member comments. 62% of those were supportive of board action, 34% opposed the board action, and 4% were neutral. Probably saying, just glad it's over. Shortly after, in the month of November, for the first time, CFPOA board and admin were approached by a group of Connestee Falls members representing STR owners questioning the board's decision. So the announcement was made on November 8th. On December 5th, in the board meeting, the board announced that they have been approached by the group of Connestee Falls members considering the retaining of legal counsel to challenge the November 8th decision. And given notice of potential litigation, the board will not comment on the STR matter further upon advice of legal counsel. So that takes us through the end of December of 23. The board stood silent. Given the litigation, reasonable thing to do. But from then through the consent order in August, the board did the best that it could to communicate developments with members. Because from December through February of 2024, there were ongoing discussions between CFPOA and the pro-STR contingent of our membership. The announcement included a May 31st, 2024 grace period, at which point short-term rental landlords would no longer be able to rent for less than 30 days. With that deadline approaching, there was real financial jeopardy associated with the loss of that rental income. And with the proximity of that risk, the plaintiffs filed suit with a petition for writ of mandamus and 8 causes of action on February 21st. A writ of mandamus is a court order that says administratively you should have filed the 6th restatement. You didn't do it. The court is ordering you to do it now. That was a claim by the plaintiffs. Right after receiving the complaint, the board and admin sent to membership a link to the SDR complaint on February 26, 2024, in an attempt to keep the community informed of what was going on. Okay. Shortly after that, CFPOA filed a memorandum with the court to dismiss the lawsuit for failure to name all Connestee Falls members as defendants in the lawsuit. Position of the association was, if you're going to issue a writ of mandamus, you need to name every member of the association potentially as defendants in the lawsuit. March of 2024, the judge hears the motion to dismiss the lawsuit, and at the end of that hearing, he directs counsel for each party to submit proposed orders for the judge's consideration. Go back to your respective camps, talk about it, come back to me with a recommendation as to what we do to move forward. Hopefully, there's some similarities between the two. I will take that under advice as I render my judgment. On April 17, 2024, the judge issued the ruling granting the association motion to dismiss the petition for writ of mandamus and one of the 8 causes of action due to failure by the plaintiffs to name all Connestee Falls members as defendants in the lawsuit. But he also gave the plaintiffs 60 days to remedy that. If they chose to go out and name all 1,600 of us as defendants in the lawsuit. He denied the motion to dismiss on seven other causes of action that included monetary damage, leaving the association exposed and what's the word I'm looking for? Exposed. Enough. April 2024, the parties agreed to mediation. We're not going to continue the litigation. We're going to sit down and hammer this thing out. But even in advance of that mediation, which was set for August, we're going to continue good faith discussions between the plaintiffs and the association. On May 1st, once again, the board and admin updated members. The plaintiffs and CFPOA have agreed to conduct a mediation to seek an agreement on all disputed issues. And between May and July, ongoing settlement proposals are submitted and countered between the litigants and CFPOA. Which brings us to August 2024. The settlement was reached and memorialized in a consent order signed by Superior Court Judge Steve Warren on August 7th of 2024. The signed consent order was shared with members the following day. Another example of keeping members updated. On August 21st, the full board authorized the formation of a short-term rental task force, and on September 4th, approved the charge that was read to you earlier for that task force. That concludes the review of the timeline. So where are we today? The 5th restatement of declaration is the latest restrictive covenant on file with Transylvania County and Register of Deeds. Per the consent order signed between the plaintiffs and the association, the plaintiffs have a sunset period to continue 2-night minimum rentals until the sunset period concludes. And that sunset period will vary depending upon when ownership of the property is transferred, but will not exceed 10 years for the 61 plaintiffs. I want to take a minute and talk about the plaintiff group. There was a lot of buzz out there that these were hedge fund people that were coming in and buying these properties. The SDR plaintiff group conducted a survey. 61 plaintiffs, they got 59 responses. 12% of the plaintiffs use their home as a primary home, do not rent it, but would like to retain the right to rent it in the future as circumstances warrant. 13% use their home as a second home. Example, Michael Crane, do not rent it. Michael was not a plaintiff, by the way, but would like to keep their right to rent it in the future. 63% of the plaintiffs use it as a second home or a vacation home and rent it when not using it. And only 12% of the plaintiff group were represented by property owners that were interested in Connestee Falls only as an investment opportunity. I've spent some time talking to several members of the plaintiff group before becoming a board member and since coming on the board. And universally, what they have said to me is, we want to live in Connestee Falls. This is the place we want to retire. This is the place we want to bring our family on vacation. So 87% of these plaintiffs are either full or part-time neighbors of ours. I want to share some more information with you about outsiders. There's a long-standing tradition at Connestee Falls. I don't like any outsiders unless they're my outsiders. I don't like your vendors. I don't like your contractors. I don't like your visitors. I like my visitors. In 2024, there were 30,744 gate passes issued to outsiders. Of that total, only 842 were associated with short-term renters. So 2.7% of the outsider total that came on board Connestee Falls were short-term renters. There's also another tradition at Connestee Falls. Whenever we see rules infractions or violations, we automatically assume that it's an outsider that committed that rule infraction. Jim Whitmore could share with you some humorous stories, quite frankly, where when you follow up, it's members. It's not outsiders that are the rules violators. So only a very, very small percentage of the outsiders coming on board are renters. This is very preliminary data and requires further review. I reviewed it again this morning with Robert Ayers. Robert confirmed the data, but it needs to be teased out further to be more meaningful. Let's talk about complaints. This again, let me give you a caveat. This data does not include rental complaints not registered with CFPOA security. So if you have a problem with a renter next door and you go next door and you resolve the problem, or you don't address the renter, or you address the owner after the tenant has left and don't go through Connestee Falls, it doesn't appear in this data. But through September of 2024, of all the complaints that were received by security, there were 27 that could be traced back to short-term renters. And those complaints regarded suspicious individuals, parking, noise, and lights. 27 complaints. In the same period of time, there were approximately 8,749 total nights leased. If you do the calculation, that's one complaint for every 324 nights leased. The question is, how big is the problem? And if the problem is not being registered via security, are there better ways for us to identify and surface and follow through and resolve problems? We'll talk about that. So what are our key findings? One, our records retention practices are inadequate and require significant upgrade. You saw that when we talked about having to chase down notes and files, okay? We just recently boxed up documents that were, I believe, Jim, were they in cardboard boxes or cardboard boxes of CFPOA documents stored in a shed over by RV number 2, RV park in RV number 2. Okay. That dog don't hunt. We can't do that with this complex of an association. Secondly, our stewardship of governing documents is inadequate. If you fail 2 out of 6, if I fail, if I get, let's see, what's the number? If I get a 60% on a test or 50% on, a 60% on the test, I failed. Okay, we have failed to follow up on and make sure that our governing documents have been filed with the county. And by the way, I'm one of the board presidents responsible for that. And so is Marty Hodgkins. Marty's closer in the chain of custody than I am, so he has more blame than I do. But I take some of the blame. Okay, and so do the 3 board presidents that served after I did. We've got to do better. There's a way to do that. And it falls upon the board. This isn't administration's fault. This is a board failure. Third, whenever possible, consensus building among members is a prerequisite to leading significant change within Connestee Falls. You have got to be looped in. I used to tell my bankers, I prefer bad news to surprises. And the worst thing you can do is surprise me with bad news. If you're going to surprise me with good news. But if you got bad news, loop me in sooner rather than later so we can talk about this and hopefully figure out a resolution. Fourth, the legislative and judicial landscape within North Carolina regarding STRs remains fluid and unsettled. There's only one North Carolina Supreme Court decision with regards to short-term rentals. There's a bunch of appeals court decisions with regards to short-term rentals, but the matter remains unsettled. Finally, our management of STR activity is inefficient and labor-intensive, and we need to develop adequate data regarding rentals and communicate this data to members. We have got to get you the information that you need to accurately consider the forces at work with regards to this matter. In typical Connestee Falls fashion, the administrative staff bends over backwards, as they usually do, to accommodate members. And last minute requests, I'll run this over here, I'll do this, I'll do all trying to accommodate members. Very gratifying, horribly inefficient, horribly ineffective. We've got to fix that. Okay. So those are the key findings of the task force. We have a group of recommendations associated with those findings. And let me just clarify something right here. The short-term rental task force is authorized to do exactly nothing. We have no authority. We are an advisory body to the board. And so in our advisory capacity, in our examination of the record and the timeline, we've made a series of recommendations to the board. It's up to the board to approve these recommendations and determine where we go from here and what next steps we take as a community. It is not up to the task force. First of all, with regards to records retention, the board has already approved an initiative to upgrade CFPOA records retention. Our boxes are now in secure storage, I believe, over in Charlotte, Jim, or something like that.
They're not there yet, they will.
They will be. They're in Jim's basement now, which is an improvement.
Upstairs, the Florida Administration Building has a look back.
Oh, that's right. That's right. That's right. And then digitized records in archives. When a future board confronts an issue like short-term rentals, they should be able to go to the record, go to the archives, identify the activity, the initiatives that were undertaken by past boards, consult with those, review those, refer to those, and helping them decide the best way forward. We can't submit future boards to what that board was subjected to with regards to going on a wild goose chase. Hey, remember Otis Schmuckatuck? Wasn't Otis on the board for about 20 minutes? Let's call Otis and see if we can, maybe he's got something. We can't do that, okay? So that's our first recommendation, which the board has already approved and has already initialized. Governing document stewardship. We need to develop an annual board review checklist for the board policy manual to include government docs checkup. Every board, when it's seated, needs to go through a review process and say, check, 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 oops. And if there's an oops, address it right then. If the oops is, hey, we had a 6-3 statement 3 years ago and we didn't file it, at a bare bones minimum, bring that to the attention of the community and let the community know of that deficiency. So the board has agreed to develop a board review checklist for the board policy manual to include government documents checkup that will happen every year. Third, building consensus among members. Draft a new section of the board policy manual regarding seeking member input and building member consensus in advance of effecting significant change. Go out to the community. Let them know what you're thinking. Seek their input, seek their feedback, take it into consideration as you map out next steps as a board. Fourth, and there's a lot of confusion about this, engage legal counsel for analysis of enforceability of the fifth restatement rental restrictions for members not party to the consent order. I've heard it said that we're seeking a second opinion, that we are seeking to, the board is seeking to undo the consent order or somehow impose the sixth restatement on the community. The consent order makes it very clear that the sixth restatement is null and void and unfileable at this point. There's no notion on the part of the task force, who has no authority, nor the board, who has the authority, to jam the sixth down on members, okay? Nor is there an attempt in this legal analysis to go back and question the consent order. We're asking a very, very simple question, as was shared with you with members in the interim status report December of last year. Enforceability. If the fifth restatement is challenged in court, is it likely to be upheld and enforced? We think it's important that we as a community know that in advance of any litigation that might be coming down the road towards us. And then only once we have that information can the board formulate a way forward with the input, feedback, and consent of the community. Any change to the declaration requires a member vote. So this is not a second legal opinion with regards to the consent order or the sixth restatement or anything of that sort. Okay? Finally, we got to get a lot better at managing what we have already. And we've made a recommendation and the board has approved the engagement with Granicus Host Compliance to support STR management at CFPOA. I want to spend a minute and share with you the capabilities of what Granicus, what they bring to the table, just real quickly. First of all, with regards to address identification, Granicus uses machine learning and artificial intelligence to go out and monitor all listings of short-term rentals within CFPOA. We give them a list of our addresses. They go out, they scan the nearly 100 platforms where these types of property are being advertised and identify them and make sure that we're aware of them. We know that there are some unidentified short-term rental properties within Connestee Falls. We want to address that and resolve that through Granicus Host Compliance. They go out and they update the activity and details on a regular basis. They give us a screenshot of activity of every active listing. They deduplicate the lists. So if you go out on 100 platforms and you got somebody listing 50 times, they reduce it to a single address and say, you've got this address. So they do that through their artificial intelligence. And they give us a dashboard of activity and map to monitor trends and break down listing compliance. Are the properties identified? Are they registered? When they have a tenant, are they paying the tenant registration fee? Those types of things. That's the address identification module of Granicus Host Compliance. They have a 24/7 hotline. You know, I don't think I'm giving away any state secrets here. We don't have security on board from midnight till 7 around here, okay? Granicus Host Compliance provides a call center 24/7 for members to contact and report complaints verbally. They can also report complaints via the internet. They record all the call center complaints. They email notifications to the association when complaints are received. They direct IVR calls and messages to emergency contacts notifying them of the complaint. So they get a complaint from a Connestee member at 2 o'clock in the morning, they contact the emergency contact. Connestee Falls Rental Hotline, you're the emergency contact for this property. You got a loud party going on. Call them at 2 o'clock in the morning, make them aware of it. You do that a couple of times, it tends to get a little bit of increased compliance. Support for emergency contacts to mark a complaint as acknowledged or resolved with the ability to send the resolution. What was the ultimate outcome of this? A hotline dashboard for tracking complaint volumes, trends, and categories, and ability to upload notes and comments on each complaint. So we'll have a centralized registry of complaints that is easily accessible by members. Members may continue to choose to address the complaint directly with the landlord, not involve the association, not involve Granicus Host Compliance, however it best works for the member, but we'll have that capability. Compliance monitoring provides up-to-date information for each identified rental unit and its compliance status. It allows CFPOA to send letters to non-compliant properties. Hey, it's been brought to our attention. You're engaging in short-term rentals here in Connestee Falls. Please make the necessary arrangements to continue to do that. They allow us to customize letters to using our own branding and letterhead, and as many letter sequences as needed for escalation. I started my banking career as a repo guy and loan collector. And my first letter was, hey, you know, gosh, I hope you sent the payment, but if not, just a friendly reminder. Second letter, you know what? You told me to send the payment, I still don't have it. Third letter, 3 o'clock Friday, or I'm out at your door at 3:10 on Friday. That kind of escalation of pressure, we're allowed, Granicus will enable us to do that. And then monitor properties become compliant after letter enforcement. Finally, automated registration. Right now, if you have a tenant and you contact the office will email the tenant registration form either to the landlord, the property manager, or the tenant. They will print that, fill it in, scan it, send it back, or they'll bring it in personally, okay? At which point, admin will enter the information into the system and then walk it over to security, where security has the information. And oh, by the way, if you don't fill out the information completely, we'll make a judgment call to see if it's still okay for you to come. Automated tenant registration includes form validation. When you fill out a form and you try and go to the next page and it doesn't let you, and it says you need to go fill this out, okay, that's part of this. And it automates the tenant registration process from form completion to routing between the tenant, landlord, the property manager, and CFPOA admin and security. So it completely streamlines and offloads so much of that kind of stuff. In summary, despite the divergent interests among members regarding the desirability of STRs, all members share in common that we want to minimize the risk of future litigation. Whatever the future of STRs within CFPOA, we want the STR experience to be as positive to members as possible and in compliance with statute, recent court rulings, and our governing documents. The board will work with members in a timely manner on a solution that minimizes the risk of future litigation and maintains the residential character of Connestee Falls and the lifestyle we all enjoy in our own unique ways. The solution may include a community vote to amend the current fifth restatement of the Declaration of Restrictive Covenants as outlined in the consent order. And the board and admin are committed to finding and facilitating a way forward in a timely manner together with a more united and informed community. We think that you need to have the facts. We think that you should have the benefit of the information that's available, that's been developed, and it'd be accurately communicated with you. Next steps, bring Granicus host compliance online, as we talked about. We want to incorporate Granicus host compliance data to provide accurate rental data in quarterly board meetings. We want to stand up in quarterly board meetings with the voice of authority to tell you, here's what's going on with short-term rentals within Connestee Falls. No more urban myths, no more urban legends, but facts. We need to draft updated rules and regulations regarding rentals and publish them to members in advance and get feedback in advance of any changes. Fourth, we're going to develop and launch initiatives to foster communication to and within the community and gather member feedback in advance of agenting any change, including focus groups, board chats, member updates via email, and additional member presentations. Questions and answers. The ground rules. Please state your name and member number for the record. It's 4 o'clock. Abide by a 2-minute limit for every speaker so that everyone gets a chance to ask their questions and no one dominates the discussion. Please do not return to the microphone for a second time until everyone who wishes to do so has their opportunity to speak. Please do not interrupt other speakers. And importantly, given where we are in the process, please understand that the board may not have a full answer to all questions, but we'll work to get one and share with members. To that end, Marty Hodgkins has graciously offered to capture questions that we may need to address further following today's meeting. That concludes the presentation. I think if you go back and you review it, you will see that the presentation is strictly aligned with the outline of the requirements of the charge given to the task force. And it does not stray from that charge. And I appreciate your being here, your interest in this important matter, and for listening to this presentation to this point. So without any further ado, please, we will entertain questions.
Somebody's got to go first. Bruce Winfield, 903. How did we find Granicus? How much does it cost, and who's going to pay for it?
We first engaged Granicus host compliance back in 2018, Jim.
Yeah. Yep.
We used them for 2 years. In those 2 years, we got 2 complaints. We decided not to use Granicus. The matter was not nearly as developed or pronounced as it is now. So we've had a working relationship before with Granicus host compliance. Steve Meadows led the initiative from the task force. There was a list of 3 or 4 providers that we contacted and settled again on Granicus because of their capability. And we believe they're a reasonable cost. I believe a year's service, Jim, $14,500
Yeah, your day.
for the year.
Right.
For the year. We think that just in terms of gained efficiencies within the administrative staff of Connestee Falls, that's probably a pretty good investment, not to mention the increased identification of other rental properties and perhaps increases in tenant registration fees that would result from that.
Follow-up. Who's paying for that? Does that come out of the CFPOA budget, or does that come out of STR payments?
It would be paid out of the CFPOA budget, but included as a revenue stream in that budget are the STR fees. So, which I believe are what, $160,000, something like that.
Fair enough.
Good.
Thank you.
And what was your name, sir? Otis Schmuckatuck. Your member number?
I'm Cheryl Manzone. I never know my member number, but I live
That's
at
okay.
453 Ustasti Drive.
Thank you, Cheryl.
My question is, how much did the litigation cost us? And how much of an effect did that have on the rising of our HOA fees this year?
My understanding of the litigation, the total cost was about $130,000. Is that correct, Jim?
Correct.
It was about $130,000. Certainly, when you have an expenditure of that size, the board needs to make a determination as to how to pay for it and how to replenish those funds. I will tell you that this year's assessment increase was 3.4%, which was a full 100 basis points below the average of assessment increases over the past 10 years or so. If you go back and if you look at assessment increases historically, a significant component of those assessment increases, there's some that's associated with operations, increased operating expenses. There's also a significant component that is related to increased reserve funding. As we add capital assets, we need to increase the funding of the capital reserve so that we can maintain the financial strength of the association. So I can't give you a specific percentage of what of that 3.4% went to pay for the litigation. Does anybody else have any?
I can answer that in the sense of, well, we gotta talk about it, yes. Why don't you talk, yeah, Mike, but the overall loss for 2024 was roughly $90,000, so we offset $40,000 and $130 from other areas where we saved some money. But then we pretty much carried the rest of it from profit that we had from previous years. So it had no impact on 2025 assessment.
Thank you.
That might be technically true, but it is a $75 per person per member liability, which represents about 60% of this year's increase in annual fees. My name's Jim Hatch. You can't have my number because I don't want to see your charges on my account, but I have 170 Inoli and 180 go on court. We're full-time residents for the past couple of years, come out of the insurance and private equity arena, still working in there. But while I appreciate the plaintiff for counsel for the plaintiff's kind of in-depth recitation of the history of the whole STR process.
The counsel for the plaintiffs?
Yeah, it
Who?
sounded seriously like
I had nothing to do with the litigation,
it
Jim.
doesn't matter.
I didn't have a thing to do with the litigation.
Ground rules suggest that we not interrupt other
Very,
people.
very well.
Okay, so the sound that I heard was a very plaintiff-oriented review of the details of something that was settled by two court decisions outside of the boundary of the consent agreement, and whether or not the obfuscation around if a non-plaintiff member is bound by the consent order is kind of irrelevant to the whole thing, because the 6th and 5th restatement issues were settled by separate court decisions. So it doesn't seem like that's really something that we need to worry about. But I did come out with 3 questions that you didn't kind of cover in those 45 minutes of this hour. So the first one is the board typically takes a unified front on these kinds of presentations, these kinds of decisions. And I don't want to assume, but I would just like to confirm that the board as a whole, each of the individual members, agrees with the content and the process that led to today's discussion or presentation. So nobody's gonna tell me later that, oh, no, I didn't agree. So you're all signed on. Dave, you acknowledged that the security data was insufficient, didn't account for most avenues of complaints. Or of the way that people might have availed themselves of dealing with a difficult short-term renter. Did you at any time say, hey, maybe we should look and ask the people who are most affected, the neighbors of those high volume renters, to see whether or not maybe they had data that they could provide you with that would be better than this assumption that the fact that the security only received 18 complaints must mean that this isn't really as big of a problem as everybody feels it is?
There was no such assumption. What I said was that there were 27 registered. There was an unknown number not registered via CFPOA. I mentioned that we're going to be having focus groups going forward. I would envision one of those focus groups being exactly the people that you're talking about. Those that have been affected negatively by short-term rentals. Those that have had complaints and issues with short-term tenants. So that is very likely to be part of the next step as we move forward.
But to quote you, it does not seem that this is a big deal as it has been reported based on Mike's data. So you've chosen to move forward on a number of recommendations with that as your kind of baseline. So
I have decided nothing. The board has decided to move forward. I'm a member of the board.
that's right.
It's not the task force that's moving forward on this.
But the task force has made recommendations and the board is making plans based on that as a kind of a baseline. So the last one that I kind of want to get into is the board spent $130,000.
Since we're going to adhere by the ground rules, I believe you've already used your 2 minutes, Jim.
But since I have.
Okay,
Apparently.
so Chris, you.
Okay,
My 2 minutes that I sent it to this gentleman up front there.
all right.
And you can have my 2 minutes.
You spent $130,000. You blew through the member approved budget last year on legal fees. I believe you are already projecting to blow through this year's member approved budget for legal fees. In seeking out this new opinion from the latest lawyer, did you also ask them if they had any opinion on whether or not courts within the county, within this area, tend to favor or disfavor overriding a decision made by one of their peers, and whether or not appeals courts tend to favor or disfavor overruling the decisions of the subsidiary courts in the superior court system here, since, as you said, this is not settled court legal issues here. I mean, yeah, Wilmington won. Asheville continues to prohibit STRs without any kind of legal ramification. So I'm trying to figure out, did you get more than just well, it might succeed under litigation?
We asked the question to advise the board on the enforceability of the restriction within the fifth restatement if challenged in court.
But the other part of my question was, did the lawyers that you talked to, either did you ask, which you said, no, you didn't ask those questions, did they opine on those as well?
We shared the consent order with the attorney. We are still in the process of reviewing what we received back from the attorney. And as we work through that, we will be appropriately communicating with members.
This is not a hard question. Did the lawyer opine in any way on the likelihood of a court to override the decision made by one of their peers or appeals courts to overrule the decisions made by the lower superior courts in this arena.
As I said, we're in preliminary discussions. That issue has not been addressed to this point.
And I will accept that as an answer. Thank you.
Thank you.
Nancy Sperling, 29 Ocasa. I have a couple of questions.
I'm sorry, could you state your name again?
Nancy Sperling,
Thank you.
29 Ocasa. The first one is, I'm assuming that in the very beginning, we allowed rentals. Is that true? I mean, you went into the history, but you didn't really talk about the rentals. So that is how we got into the situation in the first place?
The original declaration did not restrict rentals.
Okay,
And as we sit here 54 years after the foundation of the association, approximately 40% of our members are still part-time, which might suggest that there's probably a rental market here.
so then these people that have rentals, is this considered commercial property or commercial rentals? If they do more than a certain amount of days, I know you have it restricted to 30 days, but if they do 2 days, consecutive, is that considered commercial property?
I don't know that that is settled law. I do know that there have been North Carolina, and I'm not an attorney, so I'm really not going to comment on that. I do know that our documents say that there are certain commercial activities that are prohibited. Freely acknowledge that. There have been some rulings in court cases that have said that short-term rental properties are in fact should not be considered as commercial enterprises, even though they're supposed to be paying taxes and so on and so forth. That's something that needs to be sorted out as we move forward.
I have one more question. Can you clarify the 10-year rental? Is it like if I bought my property in 2010, I would be at the end of that period, so that would mean that I would not be able to rent?
It's effective as of the date of the consent order, which is August 8th of 2024. Let me mention one other thing. I believe that the consent order also says that anybody here can rent your house for a minimum lease term of 30 days. The lease doesn't have to be, the occupancy doesn't have to be 30 days. Everybody here, once every 30 days, can lease their home for as short as 2 days. So, yes,
Jane,
provided you only do it once every 30 days. Yes,
Jane Mallwitz, and I never remember my number.
I'm detecting a pattern here.
I'm sorry, name?
Mallwitz, Mallwitz.
Jane.
I have a couple of statements and then a few questions. I'll keep it brief. I'm just gonna read real quick the part on rentals in the fifth reading statement. It says, in order to protect the equity of the owners and of the association, to carry out the purpose for which the community was formed by preserving the character of the community as a residential of owner-occupied homes, and by preventing the community from assuming the character of a renter-occupied apartment complex. I think that's pretty clear what the intention was in the fifth reading statement, was to keep it owner-occupied. And from the parties in the lawsuit, some of them said that they were relying on information from the sixth reading statement, which was not recorded. I believe that's the case. However, just one example of a deed from a person that purchased that was a party of the lawsuit. On their deed, they signed deed restriction clearly stating this conveyance is made subject to the fifth reading statement. And it matches with the recorded page book. So, they knew that the definition of what they were purchasing. Third, my husband and I, so we had our own understanding, we hired an attorney ourselves. And they said that as long as your documents clearly state the restriction, that it's not over cumbersome, and it's reasonable, that would be allowed. So I'm not sure if we're getting conflicting information.
Thus the request for legal counsel.
Okay, all right, and another thing is you brought up that there was one issue with 4 college boys being allowed in a residence. As per our rules and regulations, single family housing unit is to contain a single family. So is that restriction going to be carried forth over short-term rentals, or are multiple families going to be allowed to be in there?
We need to consider the rules and regulations, and we've said that we're looking to revise those to make those consistent with our understanding of the declaration and likely to be enforceable. So that's all to be determined as we consider the issue going forward.
Okay. Another thing, I was just curious for my own information. Have any members of the task force ever had a negative experience with tenants?
I have my wife and I have a short-term rental across the street from us. We've lived in our home for almost 3 years now. The only noise we've ever heard coming from that short-term rental was the sound of children laughing as they ran around out in the backyard of the house. We've not had a problem. That's not to say that when you have a problem, it's not a problem. It is. And it needs to be dealt with through the enforcement of the rules and regulations. This is a rules and regulations enforcement issue, first and foremost. That where we have problem properties, if we have problem tenants, those need to be addressed. And by the way, the responsibility for the actions of the tenants lie with the homeowner. And so the remedies to those problems lie with the homeowner.
And another question or just a statement, has the effect of the density of short-term rentals or short-term rentals in our community been considered about the GSE for the secondary mortgage markets? You know, there have been statements that the secondary mortgage market is looking to possibly increase finance costs or limit terms and make it more stringent, which I think would be very detrimental on the community.
I would agree.
So I hope that that is considered. And I think that's it.
Thank you.
Thank you.
Tim Krupnik, full-time resident, live at 72 Middle Connestee. Let me just. Thank you. I've heard you say it a couple of times, but I think that it needs to be cleared up. No judge made a judgment in relation to who was right or wrong in the consent order. The judge just allowed the consent order to be filed by both parties. They did not rule that one side was right and one side was wrong, that the fifth was good or the fifth was bad. They said these two groups of people have agreed to these terms, and I'm allowing these terms to be agreed to by these two groups of people. Is that your understanding?
Yeah, that's my understanding of a consent order.
Okay. So when everybody thinks there's been a judgment by a judge ruling on this, there has been no ruling on this. Secondly, I'd like to go back. And from your presentation, I appreciate this, but I know how much work the task force and you have put into this. I'm well schooled on it, and a lot of this information may be new to others here. But in short, what you've said is that 40 people in a group, Roku, who are unbeknownst to most people in the community, approached 7 board members, and the board members agreed to act in the opposite way in which everything in this community had ever been done before in regards to short-term rentals, in regards to the opinions garnered in 2009 and 2016 in regards to how to limit short-term rentals. Against the 6, which was properly voted on by the community, as you stated, but not filed. That these 47 people and a lawyer were able to go into, well, the 7 were able to go into a room with a lawyer and come out and unilaterally remove the property rights for 1,600 homeowners in Connestee Falls, without considering or asking for any feedback from the community itself, and in doing so, inviting a lawsuit with legal fees totaling over $300,000 on both sides. Is that how this community operates? Is that how it can be allowed to operate? Is that something that is going to be addressed? Because I have my side of the argument that I'm biased for. No problem, I'm on the side of short-term rentals, if anybody has a question about it. But for me to live here and live under a community of 1,600 homes and a multi-million-dollar budget, 47 people and a lawyer can't go into a room and come out and say, yeah, you can't do what we've told you you can do before you bought your property. Because I confirmed with what I could do before I bought my property with the administration. And then I spent $100,000 that I didn't have to spend fixing up a rundown property in Connestee Falls, only for 47 people to come in and say, sorry, your plans are in the wind.
Can I respond?
Sure.
I didn't say that Roku walked into the board and
Agreed.
changed everything. What I said was the board became aware of Roku.
Okay.
Okay. What impact Roku has or has not had, I have no idea. I wasn't on the board at that time. I would suspect that they were one of many voices with regards to the short-term rental issue. I can't envision that group going into the board and causing this march to the rear, okay? As stated, the board sought a legal opinion as to the language of the 5th and the definition of the language in the 5th and several other issues. They got that opinion. They responded to that opinion. As for your question about, is that the way to run a railroad? Okay. You'll recall that one of the recommendations within the recommendations from the task force is to engage membership as part of board policy, engaging membership in advance of agenting significant change. So the answer to that question is, let's put something in place to make sure that we can address these challenges in a better, less divisive fashion, no matter what the subject, should something like this surface again. So I just want to clarify, I didn't say the Roku went in and that shifted it. The board became aware of it. That's all I said about that.
Understood. I apologize for giving Roku credit. However, they were the only people, it's contrary to all the data presented, contrary to all of the history, contrary to all of the documentation, contrary to the behavior of the administration. It's contrary to every single thing that Connestee Falls has ever done, filed, voted on in the history of the community. So if it weren't those 40, it's even worse, because then it's just 7 people doing it, not 47. So I appreciate the time.
I would again say that the board acted based upon the opinion received from the attorney.
In answer to that, what did the board ask the attorney specifically?
As stated in the presentation, the board asked for a determination as to whether or not the 5th declaration contained a short-term rental restriction. If so, what was the best definition or interpretation of that restriction?
So I'm sorry.
Go ahead.
So not look at our documentation. Provide us with our best guidance to remove with the least amount of liability for our community. And give us our best path forward. They asked for a way to restrict short-term rentals.
I've shared with you what what I know based upon review of the record.
And you've spoken of transparency here a lot, and I just want to say that I know people, and we've requested documents 100 times, and I don't believe that there is any documentation in this community that should not be shared with the members of the community unless it contains internal HR information or issues with HR in the operating of this community. If I asked for a legal opinion that was paid for with my dues by the board, I should be able to have access to that documentation. And I should be able to have access to any documentation I see fit as an owner here to check and make sure that the community is doing what it should be doing. And so I appreciate you ran on transparency, Larry ran on transparency, we all talk about transparency. I don't believe that the community is anywhere near as transparent as it needs to be. Thank you.
Thank you. Let me mention, Jim Whitmore, correct me if I'm wrong. There's language in our documents with regards to sharing documents, correct?
There's two things, yeah, the answer to that is yes. The second part of that is, and there's also North Carolina state statute that dictates what is allowed to be viewed by anyone or what's not. So I understand what Tim's saying. The question would be from the board's perspective is, do we want to have everything, or do we just want to provide what the state requires us to give out? And that's an open question.
Thank you for the clarification.
My name's Gail Spear. I'm at 114. Gail Spear at 114 East Point. And this really isn't regarding short-term rentals, but I want some clarification regarding some of the verbiage that's in the document. I'm in and out a lot of my house, and if I wanted some friends to be able to come up and stay in my home when I'm not here, is that allowed?
Yes,
Okay.
yes.
All right.
Hi, Marisela Katia, 96 Ulta and 923 Ubu. I might be reversed, but no. My husband and I bought here with the intention of originally as a vacation home. We have since bought a second one where we live. We just moved up here and we're going to be 12 months residents, but we still have one home that we rent. First of all, as to transparency, thank you for admitting of the flaws in the recording and the things that need to be done with declarations. I think that's important. I think that speaks to transparency. So thank you. Second, my husband's an architect, retired architect, and I've been in real estate for many, many years, extremely successful in South Florida. One of the things that I find interesting that everybody wants to complain about what happens with short-term rentals. What happens in reality is that there's tremendous appreciation and there's a tremendous ability for the flexibility of individuals that bought here that all of a sudden need to rent it for a certain amount of time, whether it's medical or not. The flexibility should exist. And I am for short-term rentals. There should be controls and there should be adhering to the rules and regulations of the community. But certainly, I think I support it. And I think it's important that we have to look at it from the level of appreciation in the real estate and from the individuals moving in who are willing to pay a lot of money for this beautiful community to keep it in mind. Thank you for your time.
Thank you.
Howard Colby, number unknown at this moment.
Howard, I think in honor of you, we're going to delete the requirement for number in future presentations. Yeah.
Or at least tell us to come prepared.
How long have you been here?
Too long. Which leads into my question. I served on that GovDocs committee that made recommendations for the Fifth Estate. And I just want to point out at that time, everything we recommended went to the board for final review before being put out to members for a vote. One of the things we recommended at that point, because the issue of short-term rentals was not a recent, we recommended that the minimum rental period be raised to 7 days. There were some who wanted a month, others who wanted keep it the way it was. But 7 days was the recommendation, went to the board. The board refused to put that recommendation out to the membership. So there was obviously a bias at that time on the board. Why not put it out to the members for a vote? But they wouldn't do it. So the question has been dragging on for a long time. Now, the other issue I wanted to raise had to do with legal settlement and the court's statement with respect to short-term rentals. It says the fifth restate now restricts all rentals of all lots to a 1 month minimum rental. Does that mean the folks who are not part of the litigation, but who have short-term rentals, now can't do anything shorter than 30 days?
I think that's what the consent order says, yes.
Right. So is that implemented effective immediately?
We've been administering it since the consent order that way, yes.
Okay. So the number of short-term rentals has been eliminated in part. Right? Right.
We've got the 61 plaintiffs. And then the fact that everybody else can rent for as short as 2 days, just as long as they only do it once every 30 days.
Right. So let's read this thing.
Right now, as constituted, the settlement says that a lease term must be for 30 days. It does not say that the occupancy needs to be for 30 days. If you sign a lease with a tenant today for 3 days, and that tenant is in place for 3 days and then leaves, you can't lease your property out again until the expiration of that 30-day period.
So that is the interpretation.
Yes.
So essentially, the number of, or at least the amount of short-term rental activity periods involved are reduced by this order. Right, so.
Yeah, other than the fact that we have unregistered, unidentified short-term rentals, and that's what we're trying to get out of the Granicus host compliance.
But in accordance with this directive, there needs to be no more than 1 rental per 30 days.
That's correct.
That decreased the numbers considerably. The other question I had. This was an issue that was raised by somebody else before. And you know, one of the things that disturbs me about a number of things that have happened. We started off getting in trouble when the board unilaterally reduced minimum rental period to 30 days. Now, that change requires a change in the declaration. And accordingly, as one can read, first paragraph, any revision of the declaration requires a majority member vote. So the board violated our governing documents in getting this whole thing started. Is there recognition now that any change in the declaration requires a majority member vote?
The likely outcome of all of this, if there is any change going forward, it's going to be the result of submitting it to a member vote. It is not an action that will be taken unilaterally by the board. Okay, and Howard, the nod to that is the incorporation into the board policy manual of language that says, in advance of agenting significant change, we need to involve membership.
But that is a requirement for changing the declaration.
To change the declaration, but you'll recall that it was the assertion of the board at the time of the announcement in November of 2023 that the declaration was not being changed.
Oh, a change, not a trivial change that they made.
They assert that there was no change made.
Well, I think if you read the two versions, we'll find a very significant change. And the last thing I wanted to point out is, aside from all of the technical issues that we're talking about, when somebody buys into Connestee or looks at Connestee to buy a home, they ought to have detailed information about what's Connestee like. And that comes across, at least it should, on the renting or leasing of lots, description thereof, which cites the fact that equity of owners of Connestee, the owners of the association, to carry out the purpose for which the community was formed by preserving the character of the community as a residential community of owner-occupied homes. That's the only description. And on that basis alone, one would have reason to believe that Connestee had full-time residents, did not have a large number of rental properties. So I think that should be modified. Let the victim beware.
Modified via a change in the declaration
A change in the change.
voted on by the members.
The reality is that the final sentence is, no transient tenant shall be permitted. How much more transient can you get in 2 days?
You bring up the issue, Howard, of ambiguous language. And the history of the courts in North Carolina is to interpret ambiguous language to, in favor of free use of the land, in favor of private property rights. There is a recent court decision, and I'm not an attorney, but I have read some articles recently about recent court decisions in a municipality where that municipality had a rental restriction that said no rentals of 1 night to 7 nights is allowed. That restriction was struck down because of ambiguous language. Now, if that's ambiguous, what about the word transient?
Well, exactly. But I mean, if somebody's reading that as the source of information about what honesty is all about, I mean.
We need to clarify the language.
Yeah.
Yes.
Isaac Allen, my member number is 37, and there's either 3 or 4 zeros in front of it. I can't remember, I'm a social member, drinks on me later.
Let's
Number 37.
let's just stipulate for the record, we're not gonna ask for member numbers anymore.
I'm a local Brevard resident and property manager. I manage short-term rentals and long-term rentals. And I manage them in Connestee and other communities here and in the Pisgah Forest, Rosman, Penrose area. And I love Connestee Falls and would like to live here someday myself. However, I have 3 kids during the Hendersonville County school system. I have a farm, and it's just not on the timeline right now, but it will be one day. I love this community. I love the amenities and the people. And what I want to say is, by managing short-term rentals, I come into contact with a lot of people that love the community as much as I do. And they enjoy spending a week or a month or even 6 months here. But in my experience, the tenants that rent long-term rentals do much more damage to the property. They cause the community more headaches. They cause the homeowner more headaches. And so in my experience personally, I would rather manage short-term rentals over long-term rentals. And that's just my personal experience. I also want to say that because of Hurricane Helene, one of your residents, longtime resident, had a tree fall on her house. So she couldn't stay in her house. And she reached out to my company and said, Isaac, I need a place to stay. And it was a wonderful thing to be able to say, yes, we have options. And because some of my homeowners live here only part-time because they have careers in other parts of the country. We were able to house some of the affected residents from Hurricane Helene,
And it's really a blessing to be able to do that and provide housing for someone who has a genuine need. Wanted to stay in their community, just felt at home here. And just wanted to say that was a blessing that we were able to do that. So thanks for letting me speak.
Thank you, Isaac.
I'll try to be brief. Hey, I'm Stu Davidson from 632 Connestee. I don't know my number either. I'm not blind here.
I don't want to hear any more reference to number numbers. I'll save an hour.
It's a little gear to get away from short-term rentals and stupid people. And granted, people here aren't as stupid as where I came from. But how do you keep the people that advertise on VRBO honest? Like if you have a 3-bedroom septic tank, you can only advertise your house as a 3-bedroom house. You know, you can't put a bed in another room and allow that to be advertised as a 4th bedroom. So how are you gonna keep that?
You're talking about enforcement issues that we're hoping will be addressed via Granicus host compliance. We don't have the parameters of the service established at this point. If that is something that is of concern, apparently as it is to you, and it's a good point, it's something we will try and integrate into the enforcement. You know, it's interesting to me that a family of 10 can move to Connestee Falls and have a lot approved for 2 bathrooms, and yet 10 people can live in that house if they choose to do so.
Septic tanks are per bedroom, not per bathroom. And
But what I'm saying is you can have a family of 10 that lives in 3 bedrooms.
no, I agree.
So I mean, it's kind of one of those nebulous things. We've got to work through it as we build the enforcement infrastructure.
I mean, that's a North Carolina, I think
Understood?
it's a realty regulation, you know, and if they, folks advertise in a VRBO and their listing agent advertises it erroneously or with false, you know, they can lose their licenses. So, anyway, just saying.
And we will certainly look to maximize our ability to enforce compliance through host compliance, because they're artificial intent. You know, what we have right now is we just kind of do the best we can. We don't have really good data. We don't have good data search methodologies. We believe that Granicus will allow us to do that. And let's see what comes from that.
I hope so. Thank you.
Thank you, Stu.
Mark Poole from Sequilly. You mentioned that commercial properties, it can't be described as commercial property. It's kind of a nebulous. How does that square with a lot of the plaintiffs being LLCs? You even mentioned someone on the committee who has 5 properties.
Manages 5
That
properties.
is a business.
Manages 5 properties here, doesn't own 5 properties here. An LLC is a typical ownership device for family-owned businesses. I had a business after I retired from banking where I did firearms training for people, and it was an LLC. It's not unusual at all for people engaged in these types of activities to put it into an LLC.
Yeah, I totally understand that,
Yeah.
but for a LLC to own property and rent it for profit, that is a business and that's a commercial business.
And what I'm saying, I'm not an attorney. And that's something that we would need to consider and get some advice on.
It just to be clear too, I've been here since 16. I was here for that 17 vote. It was poorly done. I can tell you that right now. There was a lot of discussion, a lot of bad information. There were real estate interests involved within the board itself, because I know that to be true. How are we going to prevent that from happening again?
Prevent self-dealing on the part of board members.
You got it.
I
happened before.
I
And I just want to say this. So, like I said, I've been here since 16. My family's owned property here since the 70s. We paid a lot of money over the years. I kind of resent the fact, this is just my personal opinion, that people come in, buy property for commercial profit by using our amenities.
Yes.
Now, everybody talks about the complaints, the parking, all the that's fine, those things happen. But I don't like people profiting off of what we've invested in owners. And that's what this is.
And the people that are profiting are owners that also pay an assessment,
Oh, that's true.
that also pay an amenity fee to buy into here.
But they're not using it. They're letting other people pay them to use it. How about if I just went down to the road and said, you know what? Come on to the Connestee today. I'll just pay I'll charge you so much money. You come and use the amenities.
We have
It's
a lot
not
of,
much different.
we have a lot of members that do that regularly, that have nothing to do with short-term rentals. We've had
I've
members.
heard that too.
Yeah, so, this is not an issue that's, and as you saw from the preliminary data, most of those outsiders are not renters. They're vendors.
I have
They're
heard of
contractors.
people inviting friends up just for the day.
Yeah.
And you know what? I've invited a friend up for the day and spent the day with them.
Several
Hiking and
years
doing
ago.
things like that.
Several years ago, we purged the list of permanent guests. Wasn't it like 1,500 permanent guests, Jim? And I mean, we had households here that had 30 and 40 permanent guests. And my wife has had an experience where she ran into her old hairdresser who told her, yeah, I come up here because so-and-so, I do her hair and I give her, a cut rate on her cosmetology.
I get that we get fees from the renters. That's
Yeah,
fine.
yeah.
But we also have to hire more staff, get wear and tear. There's a lot of other issues that people are concerned about, other than that guy's making too much noise, he leaves his light on all night, he parks in my parking spot, et cetera.
And
That's all I-
that's the intent of the focus groups, the future meetings we're gonna have with members to gather that kind of input, so as not to act unilaterally in this matter. But let's not forget that if it's 3% or 10% of all outside gate passes are STR related, 90% of the people coming into the gates that are using our amenities that are not members are friends, relatives, and guests of members, and contractors.
Yeah.
We had our house done, we had our roof done. Hey, I'll give you $5,000 off if you let me have access to the lake so I can fish.
Yep.
No, it happens all the time. So that's not a renter issue.
I know everybody wants to leave. I have one last question.
Chris, I want to stay here all night with you.
No, my wife was gracious enough to give me her 2 minutes, since I already gave my 2 minutes up to the other gentleman. My question is, at the gates, how do the security guards know who's renting the house and what number of people are renting the house? And if someone rents a house from one of the Airbnbs or whatever other, companies, do they just call up friends and say, yo, come on, I can party at Connestee Falls. We got a place for a week here. And do the owners even know how many people are coming?
Good question. I don't know the answer to
Because
that.
I did my own research. Last summer, I went to both gates, the east gate and the main gate. And I posed myself and I said, listen, if I owned an Airbnb here, how do you guys know how many people are renting it? I said, so just for instance, say my name's Dave Hunter.
Poor bastard.
That's all they've got. They've got a name. And they said they let any number of people in who have that name. So, I mean, this isn't even good for people who own rental properties, because it's just picking up the phone and saying, hey, place at Connestee, party's on. How do we address that?
With regards to the issue of how the gate is made aware of a renter coming on board, it's the process that I described where the registration form is sent via internet, it's scanned, it's filled out, it's either scanned and emailed back or walked over. It ends up in admin that generates a tenant package, with the tenant registration information, which they then manually walk over to the security shack at the main gate, hand it to them. They hold that, correct me if I'm wrong in any of this, Jim. They hold, so far so good?
Well, yeah, but I think the question's answered.
Well, but hold on, he asked two questions. First one, how do we know about the renters?
That's
Not just who they are, but how many of them.
Yeah, and who they invite
And
in.
can they invite other
Yeah.
guests?
Good question. That I don't.
And the answer to that question is difficult, because.
It is, because the guards themselves said, we have no idea. I just let anybody who
Many-
says 100 into the gate.
So many of the rentals might be coming in and says, Dave Hunter and Jim Bailey, two couples, rented your house. But it may be that 8 people are actually staying in the house. It might only be one name, one couple name, who's one who went to Airbnb and booked it. And those 2 people are on the lease, but there's 6 people that show up. So once they show up, we know, we register them, but once they're in here, they're no different than you. They can invite whoever they want. If they have friends that live in Hendersonville and they want to come over for the night, I can't stop that. They're gonna call the gate or have the same access you do for those 3 days and invite people in. That's their right, as renter, they can invite you.
And I would imagine with the engagement of Granicus, we can begin to monitor that and restrict that.
Yes, no, not really, because the same thing, so if I rent the house and then, or 2 couples rent the house and then we say, hey, we have 2 other friends that live in Hendersonville and 2 friends that live in Toxic, hey, why don't you guys come down and stay with me for 2 days during our rental? I can't stop that.
Don't they have to have a POA number to?
No,
Be allowed in?
it's just like if you have friends that are visiting and you wanna have them stay overnight.
Well, I gotta get on the POA website.
Yeah, right, they have access to the 3 days.
But I thought that you had to sign the lease in order to get in. So if your name's not on the lease, how are you getting the gate?
Well, the renter gets in, but that doesn't stop them once they're in there, like.
How do they have access to the gate house?
They have, so when they check in, they're getting basically a pass, right, a 3-day pass with the barcode.
So they would have to contact the gate.
And then they contact the gate and say, oh, by the way, tonight, we're gonna have 2 friends come over. They're allowed to do that.
They don't have access to gate house.
I can't stop them. They call the gate, or I'll stop at the gate and say, no.
So I could.
Yeah, you have to give them a way to have friends or visitors or family come visit. They're here.
The landlord, they set them cards, not owners, not members.
Right, but.
They sign the lease.
Okay, we,
But at least, let me just, does not stop me. I mean, I'm sure all of you have rented somewhere or went to a hotel or whatever. You rent a hotel room, but you have a friend who decided to stay overnight in your hotel. You don't tell the hotel that.
You're not getting how many. That is a liability. That's a
Oh, yeah,
liability.
I'm not saying it is. I'm not saying it is. I'm just saying the reality of how it works.
and something that hopefully we can address via the engagement, at least partially to whatever is possible through Granicus host compliance.
Tim, just have one more for you.
Tim?
One more thing.
Okay.
In regards to this, I'd like to point out that in the eyes of the law and our documents, there is no difference between a tenant, your guest, your family that doesn't live here, your visitors. It's all one big pool of people.
Yep.
It's not tenants who don't live here full time and your son and daughter who come up here for the weekend.
Right.
They all have the same rights to everything within the community once they're staying within the community.
Yep.
So if they want to invite people over for dinner, they can invite people over for dinner. It's the same thing the same way if you're, let's say you have 10 children and 47 grandchildren. If you invite your whole family over, 47 people, is that too many people to come into the community? Are you overusing an amenity? I mean, you have to look at this in the documentation of the language, the way that our documents differentiate between tenants, guests, family members, non-residents, and residents. And then one last thing is that in a pile of negativity, I understand I'm gonna get moans and groans, but there is irrefutable evidence that short-term rentals have positive benefits that have been glossed over and not talked about all at once since we've been in. And I'd like to point out that according to our own documentation, 50% of all new home buyers in Connestee Falls rented here first. Because it's a big investment and you want to make sure you're experiencing what it's like to live here on a day-to-day basis. Are you willing to write off 50% of your home buyers?
Yes. You get that.
Yeah, we do homeowner survey for over 10 years. Every year we do it. That's data that we know.
And they can rent for a month.
That's, I just want to understand, is that,
Okay, we're closing in on 5 o'clock.
I'm finished. Thank you.
Thanks, Tim.
Can I just make one comment?
Sure.
Be brief. As a person that lives alone most of the time, since my husband travels, we live in an adjoined unit. with a shared driveway. My top priority over a couple of dollars is my safety.
Sure.
I like to know who my neighbor is. I don't like to have to worry that I'm walking my dog. I have to make sure I lock everything up. Who's over there? I would never have bought here if I would have known that my neighbor was a short-term rental. My safety is my top priority. Yeah.
Thank you.
One more. It's the last one.
Last one.
Real short, 31 West Court. The gentleman that mentioned that 7 days was proposed several years ago by a committee, but it never got submitted to the membership for approval. In my opinion, that's a reasonable compromise. And if the board went forward with that and put it up with a vote, my guess is it would be adopted. So let's settle this thing and end this intransigence and additional legal expenses yet to be incurred.
Put it to a member vote, in other words, right, Craig? Is that what you're saying?
Please.
Okay. Thank you all for being here. Looking for further communication. Thank you.